Hearing in the appeals, the Queen on the application DA and DS and others against Secretary of State for Work and Pensions.
Just to remind everybody that the court has made an anonymity order in these cases. The court has ordered that no one shall publish or reveal the names or addresses of the appellants who are the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of them or of any member of their families in connection with these proceedings. We say that, of course, for the benefit not only of those in court, but also to remind everybody that these proceedings are broadcast live, and so people have to pay particular attention to the anonymity order. It's for that reason that I stress it. And I apologise for our being a bit delayed by unfinished business in relation to the case that some of us were hearing this morning. This is the first time, I think, that we have finished a case at 1 o'clock and then decided to start another one at 2 o'clock. If my lords are content, we'll go on till 4:05 today, so we try and make up a little bit of the lost time. And I think, Mr. Drabble, are you kicking off?
May it please the court. In this case, I appear for the appellants in the DS litigation.
You don't need to read out all the names of it.
That
will waste a lot of time.
I was rather hoping that I might get that indication, but I have written it all out rather carefully, but we'll progress without going through that.
Well, everybody's welcome.
There are two housekeeping matters I should mention. First of all, there has been a flurry of late witness statements, yes, most of which are now contained in a bundle which the court has copies of. But in addition, there is a witness statement from Ms. Garnham lodged on behalf of CPAG, which went in just before close of play last night. Yes. There's no objection from any party to any of the witness statements being in front of the court, as I understand it.
Yes, and, well, the government started it and the appellants retaliated, basically.
Exactly. And for my part...
no disrespect is meant to the government by that. It seems that it's better to have the most up-to-date information available. So, no, we agreed that we would admit it all. Yep.
The second piece of housekeeping is that your ladyship and my lord should have on the bench a document described as DS's appellant's key references, which I will introduce in relatively shortly. But what it is an attempt to put together in one place the references to the public policy documents that are relevant to the issues in the case. I'll say a word about why we've done that in very, very shortly. But I hope the court will find it useful. Now, your ladyship and my lords will have seen, of course, that this is our challenge to the revised benefit cap made under the Welfare Reform and Work Act 2016, which amended Section 96 of the Welfare Reform Act 2012. Parties have called the version of the cap introduced by the 2016 legislation the revised cap, so that we have, in terms of nomenclature, the original cap introduced by the unamended form of Section 96, and now the revised cap. And it was, of course, the original cap which was considered by this court and upheld by a bare majority in case reported as SG and against the Secretary of State for Work and Pensions. Now, in relation to the revised cap, we advanced 3 grounds on which we say it is unlawful. First is ground 1, identified in our printed case, which is an allegation that it discriminates against children of lone parents, contrary to Article 14 of the ECHR, read together with either Article 8 or Article 1 of the first protocol. The second ground is an allegation of discrimination against lone parents / women, again read together with either Article 8 or A1P1. And the final and third ground identified in the case is that the revised cap is irrational. In relation to those grounds, it will of course be necessary to consider two major issues which were extensively considered in SG. They are the Secretaries of State's threefold justification, which I'll come to in a moment. This obviously depends on the form or on the policy being pursued by the Secretary of State. In connection with this, and this is the reason for the clip, it is noteworthy that there is no formal policy document equivalent to either a green paper or a white paper or similar published document indicating what the policy is. And so I intend, with the Court's leave, to take your Ladyship and my Lords at a relatively early stage to as full a set of references as we've been able to put together of official pronouncements of the policy pursued by the CAP outside parliamentary debates. It's the public, I call rather badly, the public-facing documentation which shows what the policy was said to be. And in fact, they are largely to be culled from relatively short documents, such as equality or impact assessments. The second area of background material that falls to be considered is that which relates to Article 3 of the United Nations Convention on the Rights of the Child. And of course, in SG, 3 members of the Court held that the original CAP breached Article 3, and it will be necessary to look at the reasonings that led to that conclusion to examine whether or not it applies to the revised CAP. It will also be necessary to look at the relevance of a breach of Article 3 to the grounds, the allegations of discrimination that we make, i.e. discrimination contrary to Article 14, read together with either Article 8 or A1P1 or both. With the Court's leave, I propose to proceed as follows in broad terms. Firstly, the statutory scheme. Obviously, this involves Section 96 of the WRA and the regulations made under it. However, there is also, as the Court will have seen, a detailed regime imposing conditions of conduct backed up by sanctions, which are designed in the general benefit system to ensure that benefit recipients take appropriate steps to look for and obtain work. Detail of this is described in Miss Garnham's witness statement, and it wasn't considered in real detail in SG, so it's, we say, a factor that is in play now in more detail than it was before. Thirdly, the third head of place I want to go is to look at the state of play in relation to the Secretary of State's case on justification, which involves looking at the references in our clip in the published policy documents and looking in some detail, some more detail, at aspects of that material. So the statutory scheme, Court will pick up the core volume and our printed case, paragraphs 14 to 39. Which is, it's a heading, the revised cap and the benefit system, 1/3 of the way down the page, which is at MS 8299. my lady and my lords, just run an eye over that. Your ladyship and my lords will see that the detail of the statutory scheme is described between paragraphs 14 and 26. I'll take the court in a moment to the background statutory material. Then we pick up the sanctions regime, paragraphs 27 through essentially to 36. The comments on paragraph 34 to 36 are really dealing with what the respondent says about our comments on the sanctions regime. The description of the sanctions regime is 27 through to 33. So if I can then ask the court to look at the core authorities bundle, first bundle, tab 1. We have at tab 1, MS 14, Section 96 of the Welfare Reform Act as originally enacted. We'll see that Section 96 provides that regulations may provide for a benefit cap to be applied to the welfare benefits to which a single person or couple is entitled. Then subsection 2, for the purposes of this section, applying a benefit cap to welfare benefits means securing that where a single person or couple's total entitlement to welfare benefits in respect of the reference period exceeds the relevant amount, their entitlement to welfare benefits in respect of any period of the same duration as the reference period is reduced by the amount up to or equaling the excess. And then there's a regulation, there's a definition of reference period in subsection 3. Subsection 4 provides regulation making power. Your Lordship, my lady and my lords can see in 4A and 4B deal essentially with the mechanics of the cap. And then subsection 6 is an important provision provided in relation to the original cap that the amount specified under subsection 5 is to be determined by reference to estimated average earnings. So subsections 5 and 6 together tell the Secretary of State to fix the cap by reference to average earnings. And then that's further defined in subsection 7. In this section, estimated average earning means the amount which, in the opinion of the Secretary of State, represents at any time the average weekly earnings of a working household in Great Britain after deductions in respect of tax and national insurance contributions. And 8 gives him wide power to estimate earnings in such manner as the Secretary of State thinks fit. And then my lady and my lords will see in subsection 10 that there's a wide definition of welfare benefit as meaning any prescribed benefit, allowance, payment or credit. So that's the original cap, changed in some substantial ways by section 96 as amended, which the court will find at tab 2. And the changes are substantially that if the court looks at section 96(5) large A, reference to earnings as the base for the cap has been replaced to a fixed financial sum.
Page number, please.
Sorry, my lady, I'm sorry. MS 18.
I'm having a lot of trouble accessing and manipulating the bundle, so I've been doing all sorts of fiddling, so I can't look about. And so, could you give me the page
I'll
number?
try very hard to remember to give your ladyship the MS numbers as I go along.
Please. Yes. So, what is it?
It's MS. Section 96 starts at MS 17.
Right. Thank you.
And we were looking at 5 large A, which is at MS 18.
I see it.
So the reference to average earnings in the original version of the cap has been replaced, as I say, by a fixed amount of 23,000 or 15,410, depending on whether you're a couple, single person, for persons resident in Greater London, and 20,000 or 13,400 for other persons. On the face of the statutory scheme, no explanation of that sum, and we'll see what explanations have been put forward for that sum when I go to the policy documents that's in our clip. And then another change is, if your ladyship and my lords look at subsection 10, there's a definition of welfare benefit, and it means, and then there's a long list of welfare benefits. Which include child benefit under little b, child tax credit under little c, housing benefit under little e, income support g, job seekers allowance h, and then relevant later in the chronology than our immediate cases, universal credit under k. So the effect now is that section 96(1) provides that regulations may provide for a benefit cap to be applied. We're told by subsection 2 that applying a benefit cap means, and then securing that their benefit doesn't exceed the relevant amount.
In the old subsection 10, welfare benefit meant any prescribed benefit, allowance, payments or credit. Was the prescription of those significantly different from the list that you're showing us now?
I think the answer to that is no. The difference, which may or may not be relevant depending on how the argument goes, is that there's no discretion to alter the list in the revised version. So there was an argument, I mean, let's face up to this, it's going to be relevant. There was an argument in SG about whether or not you could simply omit the child-centred benefits, if I can call them that, the child benefit and child tax credit from the prescribed benefits, which were at large under 9610 in its original version. That precise argument isn't available. So if there is a breach, then that is an issue which will need to be addressed. Then there are exceptions to the revised cap, and your lordships and my lady will see those set out in our printed case going back to MS 8300. attempted to describe them between paragraphs 19 and 23. In particular, if the court looks at Regulation 21, 8300 again, in MS terms, persons who are in receipt of certain benefits are exempt from the revised cap. See Regulation 75F. Give the court the reference to that in just a moment. And then we set out in paragraph 21 the benefits that are in play in relation to that. And in paragraph 22, MS 8301, we say the other way in which a benefits claimant may avoid the revised cap is claiming working tax credits. For a couple's condition of entitlement to this benefit, they must between them work 24 hours a week, with one of them undertaking a minimum of 16 hours. A lone parent must undertake a minimum of 16 hours work by herself, and then effectively we are in the second part of paragraph 22 making a submission about the additional difficulty that a single parent will face in getting off the cap compared to a couple, because of the very simple thought there's only one of them that has to do both the work and the childcare. And that's a theme that we pick up further on in paragraphs 22 to 23. The regulations that are relevant to all of that are to be found at tab 4 of the authorities bundle, starting at MS 32. And in particular, if my lady and my lords look at MS 44, we have Regulation 75F of the Housing Benefit Regulations 2016, which essentially sets out, I hope, the terms of the exception that we have in the printed case. I don't think anything turns on the detail of that in the sense that there is no argument about construction. It's just simply getting the scheme accurately described. Now, as I say, that is the basic statutory scheme and the most important parts of the regulations. As I said a moment ago, in addition to that, we say that it's important to bear in mind the sanctions regime, which is the easiest way for me to describe that is to ask the court to look at our witness statement.
Before you do that, Mr. Drabble, where do we get the distinction between the amounts for a single person?
Very good question.
Because I don't think you've shown us that.
I don't think I have.
And as that is the real focus of your case.
Yes, indeed. Let's try and answer that question. It'll be in the revised cap. Not quite sure there's a complete answer. If you look at 96 subsection 5 at MS 17, Ladyship will see that subsection 5 at the foot of the page says regulations under this section may make provision for determining the relevant amount for the reference period applicable in the case of a single person or couple by reference to the annual limit applicable in the case of that single person or couple. And then in the statute at 5 large A, you have the two amounts for annual limits. Now, I'm aware that linguistically there's a slight missing bit in there.
And 5B allows the regulations to have different prescribed descriptions of single person and different prescribed descriptions of couple.
Yes, but that's not quite your
That's not
ladyship's
quite-
question.
no, it isn't.
You're,
It isn't.
you're asking, what is it?
What is it
Certainly
that
my
gets the
understanding,
difference?
my understanding is that the annual limits are fixed
Yes.
by the primary legislation. For better or for worse, they're fixed by the primary legislation in the form of the two separate amounts for couples and single persons that we see in 5 large A.
Yeah.
I haven't actually found
Where it says
quite where the
one
jump
applies,
from subsection
the
5.
22,000 in Greater London applies to one class of people, and the 15,410 for persons in Greater London applies to another class of people.
That's in the 75 CA of the housing benefit regulations on MS 39.
Yes, that's what I'm being told by Miss Leventhal. But I'm not quite sure that's the answer to Baroness Hale's question, because that's in the subordinate legislation. That's an exercise of the power under 5B.
Yes.
It's not telling us what significance of the two figures can't kind of feed back into the primary legislation.
When I read the two figures, I did wonder,
Yes.
just reading that section, how they fitted in.
Well, I think the simple fact is that we may not quite have the right bit of the text. The practical answer to the question is indeed Lord Hodges and Miss Leventhal's point about regulation 75 CA. And
Well, if you read the two together, I think you can see what 5A must be saying.
yeah, it is undoubtedly the case that 5A evidences a fixed limit in the primary legislation.
It does, and two fixed limits
Yes,
within each of the geographical
yes.
areas. It does that. I was really asking about where do we find what assigns what class of persons to each of those two figures. And 75...
That's the question, and the answer is 75 CA, I think.
It does, yes, that does seem to be it. I mean, this is really crucial to all of your arguments, so it's good to get it. Where do we find the definition of single claimants?
Subsection 10 of
MS 18.
That's a single person.
Subsection 10. I mean, leadership and my lords convened subsection 10.
That's not a definition of single claimants.
Single person is defined below, 4 down. Single person means a person who is not a member of a couple.
What's the MS reference to, subsection 10?
MS 18.
18.
Yes, but of course that would include a lone parent.
Yes. Yes, absolutely. So these are fairly familiar concepts with the social security legislation generally fiddles around, if I can use a colloquialism, with concepts such as family or assessment unit and so on. These are all a particular legislative expression of those concepts. But the answer to the question of who is a couple and who is a single person is undoubtedly subsection 10. Maybe I'm just being slow and awkward. If one reads 5A and 5B together, 5B says that regulations under subsection 5 an unadorned subsection 5 may specify which annual limit applies in the case of different prescribed descriptions of a single person. So the legislative drafting is certainly assuming that the regulations will assign the higher or the lower figure for Greater London, or the higher or the lower figure for persons not resident in Greater London to one or other of the categories. And it may simply be that it goes no further than that. That's what the regulations do.
We haven't found a definition of single claimant, but we assume it's a claimant who is a single person.
We find a definition of a single person.
Yes, I've seen that.
Well, that's because the Act uses the expression single person, doesn't it, in 96(5). It's the regulations which speak of claimants. There we are.
Yeah, and that was a subsection 5 in that form was a feature of the original cap, of course.
Quite.
I mean, it's always, you've always had.
Are you getting some help there, Mr. Sheldon?
My lady, I am. It's not in the bundle, but it appears in Regulation 2 of the regulations, where single claimant is defined. Claimant who means a claimant who neither has a partner nor is a lone parent.
Yes, this you see, I'm chasing this whole thing through because this is what we're grappling with. Yes.
Lady, we will make available to you that particular regulation.
Just give me that again. A claimant who is neither.
It's defined as, it means a claimant who neither has a partner nor is a lone parent.
I see.
All right.
I think it would be helpful to have that.
Yes. And the result of that is that if we go back to 75CA,
Can you remind me where that was?
MS 39,
Thank you very much.
There is the effect of that the higher of the two
Yes.
limits in each case applies to single parents,
Yes.
lone parents, I'm sorry.
Yes.
Yes.
Yeah.
Well, that's what I was trying to get to.
yes, your
How
relation
we
entirely
got there.
right to push me into getting there, and you're entirely correct.
Well, Mr. Sheldon's been very helpful. Yes, right. So back to 75CA.
Yes, and together with Mr. Sheldon's Regulation 2, you read 75CA2 as applying the 15,400 Greater London limit to single claimants, i.e. not lone parents, on the Regulation 2 approach. $23,000 to all other claimants in Greater London. Apologies for taking some time to explain that or get it right. If we go then to the sanctions and conditionality regime, say the simplest way of explaining that is to ask my lady and my lords to look at our witness statement, which is again in the core volume, at MS 6536. And it's paragraphs 28 to 40. Paper, page 15 of it's part 1 of our appendix, MS 6536. At the very foot of MS 6536 is a heading, Income Support, JSA, Conditionality and Sanctions. Ms. Garland refers to conditionality in paragraph 28, and then in paragraphs 29 through to 38, so indeed to 40, describes the conditionality regime. So that, for example, if one's looking at income support, it says the conditions relating to income support depend on the age of the lone parent's child. Court can see those varying depending whether the child's under 1, when there are no work-related requirements. The child turns 1, the parent is required to take part in work-focused interviews, usually once every 6 months. At these interview employment plans and possible training opportunities will be discussed with a view to the parent's eventual return to work, which is not required to work as a condition of receipt of the benefit. Then 33 describes the additional activity that's required of someone whose child who has turned 3. (32) describes the shift over to JSA, Job Seekers Allowance.
You better keep your voice up, Mr. Drabble.
Sorry. Paragraph 32 describes the change over to Job Seekers Allowance 6537, MS 6537. Paragraph 35, MS 6538, introduces the concept of job seekers agreement as a prerequisite for receiving JSA. Job seekers agreement being referred to as a claimant commitment. Paragraph 36 describes the sanctions, the actual sanctions. Paragraph 38 makes an important point from the point of view of the structure of our argument, where Ms. Garland says, I would stress that even JSA claimants only required to actively prepare for and seek work, not necessarily to find it, in order to receive support, recognising that not everybody finds a job straight away. It makes a fairly obvious point. This may be because of local labour market conditions, for example, a lack of jobs which fit with childcare or school hours, or because they need to train or gain experience first. And then all that ends up with the forensic point in paragraph 40, The point here is that there is a carefully calibrated and tiered system of responsibilities and work incentives for lone parents, which reflects the extent to which they can reasonably be expected to be improving their work prospects and or actively seeking work, bearing in mind their caring responsibilities. This system is coupled with an already strict sanction regime, which penalises lone parents if they do not comply with the conditions of their benefits, and therefore provides a strong incentive to comply. A task for the Secretary of State is to explain why, against the background of that carefully calibrated and tiered system, it is appropriate or sensible to impose the cap as a mode of incentivizing work. There is, on the face of it, a detailed system that's designed to do precisely that.
A bit more calibration.
The cap is a funny piece of calibration because it simply means that there's a lower limit, and then the sanctions are applied to further reduce that if there's an actual breach of a particular requirement to attend a job interview or whatever it is.
So the sanctions regime is not under challenge, that's accepted.
No.
Indeed, that's the foundation or argument, we don't need something
Well,
else.
we positively rely on it in this context, absolutely.
And are we going to be shown an explanation of that in due course?
We're going to be shown what the Secretary of State says about it. It's one of the building blocks I should be coming to fairly rapidly. Yeah. I mean, he says, well, I'll come to what he says when we come to it.
Yes.
So, that's the conditionality regime. Next port of call is to summarise, as it were, the differences between the revised cap and the original cap. And there are three obvious ones. First of it, that the revised cap figure levels are lower. Cap is now, outside London, £384.62 per week, as opposed to 500, some 23% lower. The result is that the numbers affected are significantly higher. 88,000 likely to be affected. All these figures are in our case, 64,000 more than were affected by the original cap. A third, an obvious difference, is that any objective basis for setting the level at the amounts we have seen has been removed. We've seen that in relation to the original cap, it was tied to average earnings. Always that tie was always subject to the criticism that the formulation did not recognise the fact that the earnings were always supplemented by benefits. However, even that link has gone. And we submit it's quite impossible to describe the new cap levels as anything other than arbitrary. They do not relate, I'll take your lordships and my lady to the material behind this, they do not relate to any assessment of need or any form of comparison with a deprivation level or a poverty level or any such index. The exercise is simply not being carried out. So against that...
Another change, I think, from recollection, is that the distinction now drawn between people in London and people elsewhere is an innovation.
Yes. Yes. One of the effects of all these changes is to mean, and we'll see this in a moment, that whereas it was originally said that the cap could be avoided by people moving, and that was the sort of choice that people in work had to make, and therefore it was appropriate for people on benefit to make it. That has become pretty well impossible. The cap is extended geographically, and the possibility of moving to avoid the effect of the cap is diminishingly small. It's covered in detail in the evidence of shelter, on which I rely, but I shall leave it to Mr. Westgate to say it.
At the time of the previous hearing, my recollection is that the people caught by the cap were mostly resident in Greater London.
Yes, that's right. I mean, right, but not entirely. It wasn't a universal picture. It was certainly right that it was large city centres. Your Lordship may recall that CPAG put in a series of tables showing the position. And effectively, if you were in central London, central Bristol, central Manchester, then you were potentially caught by the cap, but you could avoid it by moving. We'll see that in just a minute. So the impact in numerical terms on the people who are caught by the cap, we have set out in paragraphs 47 to 54 of our printed case at pages, at memory stick 8311 to 8313. If your lady and my lords look at who is affected by the revised cap, top of memory stick 8311. And we've given a breakdown in paragraphs 47 through effectively to 52 of the groups who are caught by the cap. The figures in paragraph 51 are pretty striking.
I don't understand that. All right.
And paragraph 50 makes the important point in terms of disparate impact, or more generally, that 71% of all affected households are lone parent households. So can I now move on to the next task, which is to show the court the evolution of the policy justification for the cap in accordance with the crib sheet that I put in at the very beginning. The court will remember, set out in very short terms in the statement of facts and issues, the estate puts forward three aims for the cap. Paragraph 11 of the SFI, MS 8212. Paragraph 11 just simply recites, as with the original benefit cap, the government contends that the revised benefit cap pursues three aims, which are making fiscal savings, ensuring fairness between taxpayers and workless households, and incentivising work. And if the court will then turn to the first document in the clip. We have tried to isolate the public statements relating to what we call the fairness aim. The basic thesis behind all this is that the fairness aim was always couched in terms which included a reference to those on benefit facing the same choices, making the same sort of decision as those who were in work. And members of the court will recall that CPAG said in the original case, the original SG, that that was misconceived because of the amount of benefit paid to those in work. But can I just track down precisely what the public-facing statements are? So original cap, if you go to Part 5 of the appendix in DA, it's paper page 1824 of the appendix memory stick MS 6335. And we are looking at impact assessment of the 23rd of January 2012. Policy is described in these terms under the heading Summary, Intervention and Options. What is the problem under consideration? Why is government intervention necessary? And then the benefit cap should be seen in the context of the budget deficit and the reductions in public expenditure that the government is making to tackle it. Spending on welfare increased by 45% in real terms in the decade 2009 to 2010. In that year, the government spent 192 billion on welfare payments, compared to 35 billion on defence, and so on. And then the state can no longer afford to pay people disproportionate amounts in benefit each week in welfare payments, sometimes in excess of what someone in work may take home in wages. So from 2013, the government will introduce a cap on the total amount of benefit that working age people can receive, so that workless households will no longer receive more in benefit than the average wage for working households. So the particular problem that's identified is that people are receiving in welfare payments in excess of what someone may take home in wages. The remedy is to ensure that workless households will no longer receive more in benefit than the average the average wage for working households. If your ladyship and my lords then look at the next box, the objective of the policy is described. There are 3 bullet points: deliver fiscal savings, and then sit alongside the other measures announced in the spending review to make the system fair and affordable, as workless households will no longer receive more in benefits than average working households receive in pay. Then improve working incentives. Next box describes policy options that are under review. It can be summarised as cap everyone. That's the first 3 lines. And then last 3 lines of the box. Consideration was given to setting the cap at a different level. The policy is intended to promote fairness between those in work and those receiving working age benefits. So the decision was taken to base it on net median earnings, as this figure best represents the average take-home pay of working households. So the policy is described as achieving fairness by limiting the income of those on benefit to the average take-home pay of working households. Then over the page, second box down, we have other key non-monetised costs by main affected groups. This is Lord Reed's point about what people possibly needing to move. The cap is likely to affect where different family types will be able to live. Not possible to quantify these costs because they are based on behavioural changes which are difficult to assess robustly. And then again, the fairness objectives described in the two boxes down, other key non-monetised benefits by main affected groups. Measure sits alongside the other measures announced in the 2010 spending review to make the system fair and affordable, as workless households will no longer receive more in benefits than the average working family receives in pay, and will improve working incentives for those on benefits. So that's the first policy document relating to the original cap. The next is the equality impact assessment, which again the court will find in part 5, paper page 1849, MS 6360.
6360.
6360. Yeah. But that's where it starts. So at 6362, in the introduction to the equality impact assessment, second bullet point towards the foot of the page, benefit cap will, and then the first bullet point is acted as an incentive to work, second bullet point, promote greater fairness in the welfare system between those out of work or on out of work benefits and taxpayers in employment by preventing households on out of work benefits receiving a greater income from benefits than the average weekly wage. And then there's the fiscal financial deficit aspect of the policy. Described in similar terms in paragraph 1 at the top of MS 6363. And then finally, we should draw attention to paragraph 18 on MS 6368. The heading, what are we doing in mitigation? Description of the various options the people affected by the original cap would have had, which include moving, starting work, reducing non-rent expenditure, making up any shortfall in housing benefit, and so on. That is effectively the totality of the non-parliamentary statements about what the policy is, or was, at the time of the original cap. We have referred at the footer of the second page of the clip to a statement by Chris Grayling in committee, which we have set out there, which repeats the recurrent theme that people in work have to take decisions about what they can afford to do, the last part of the quote. We then move on to the revised cap. In DA Appendix Part 3, paper page 966, MS 5477, we are in impact assessment for the revised cap. First box, what is the problem under consideration? 1/3 of the way down the page. It starts with the claim the current benefit cap has been shown to be successful with more households looking for and finding work. The long-term positive intergenerational effects from people moving into work are well known, and therefore to encourage more households to move into work, a new lower tiered cap has been designed to strengthen the work incentives for those on benefits. Also helps in tackling the deficit and consequent reductions in public expenditure and help the government making a return to sustainable public finances. Valuation evidence shows the existing benefit cap at £26,000 is improving work incentives, promoting fairness between those in out of work benefit and taxpayers in delivering savers. Reducing the cap builds on this, delivering further positive changes. And then if we go down the box, next box down, what are the policy objectives and intended effects? And it's the second point that I'm interested in for present purposes. And it's described as promote even greater fairness between those on out-of-work benefits and taxpayers in employment who largely support the benefit cap, the current benefit cap. Next box down describes the options that they've considered. Court will see that the last 4 lines say the current cap meets policy intentions, opportunity to help further build on success with a lower cap. We believe that the lower levels further enhance work incentives, striking a balance between fairness. Then all of that needs to be linked to the box in the middle of the facing page, paper page 967, MS 5478. Households who may be affected by the cap will face the same choices as working families over where to live and manage their household expenditure. Again, the recurring theme of the same choices. Now, effectively, we've given the court some further references in the note. That is pretty well the sum total of the policy justification put forward outside Parliament for the cap, and the theme is fairness in a comparison either with earnings in the original cap or just even greater fairness by removing the comparison with earnings. So we say that that material demonstrates that the fairness aim is not sustainable if by the fairness aim we mean that the cap puts the claimants in a position where they're subject to the same financial rigours as working families. And the position that working families is in can be seen if we go to Miss Garnham's witness statement, MS 6536, paragraphs 19 to 22. So we're in the core volume. And the court can see from paragraphs.
What's the MS number, please?
So it's 6536.
This is Ms Garnham's witness statement.
It is indeed. And it essentially proceeds by setting out what my clients would receive if they were in work. With earnings at the level of the cap, the revised cap. And the court can read paragraphs 19 to 21. Coming to the conclusion in paragraph 22, stark point demonstrated by these tables that the benefit system does not treat £20,000 per annum, the level of the revised cap outside London, as being an adequate income on which a lone parent such as NL can raise her family. She is awarded a significant amount of in-work means tested benefits in addition by reference to the needs-based system. And there's a further passage to broadly the same effect at 6546. Paragraphs 72 to 75. Paper page 25. Statement at the end of paragraph 72, referring to the Secretary of State's evidence and saying, last sentence of 72, other than the reference to 4 out of 10 households earning less than the lowered cap amounts, nothing to explain how the new levels are considered to be a reasonable limit or set an appropriate benchmark. Tables are at 6607. The central bit of the table is actually 6609. That's okay. Page 88, our Appendix 1. The graph, and we have actually got coloured copies of the graph if the court wants them. I'm afraid I tend to work off tables and not graphs, and it's the box at the top of the page which tells you what the figures are.
Which MS page are we on?
It's 6609.
Well, it comes out in beautiful Technicolor on our screens.
Oh, well, you're better off than me. Well, those of you who are working off screens.
We've got both the benefit of the figures at the top, and then we've got the pretty colours for the...
6609. You'll have to convert, Mr. Drabble, to the computer.
Well, I think there are limits on the length of one's career, and I think that might be
You're far younger than I am.
might be the dividing point.
You've got
Well, I
happy
can't
nods
possibly
from two
work without
members of
getting
the
lost
court.
in reams of paper. That's not.
So what are we to look at here?
Yes.
The point is that if you look at the box having turned the page over, the top of 6609, there's a summary table for the graph, and that is telling you what, for example, my client NL working 16 hours for 20,000 net, in other words, the wage, the equivalent of the cap, would have net earnings of 20,000, and the various benefits are set out, and the total income is not 20,000 at all, but 31,957.
Yes.
And the similar exercise for DS. Some members of the court, this is a very similar exercise to that which was carried out in the tables in SG or JS or whatever one calls it.
Yes.
But the basic point is that the take earnings is only to take half the story, because people in work with given earnings, now the tax system, it doesn't work by tax allowances, but works by the payment of child tax credit and so on, build in financial benefits, in-work benefits. I feel certain nostalgia as one looks at the MS 6595 onwards. There are all the tables that are referred to in the judgments in SG. We've done the same thing, essentially, in relation to that box at the top of 6609.
Did you say you had a paper version of the coloured?
Yes.
I, for my part, would quite like that.
I'm sure everybody would welcome one.
If everybody wants one, they can have one.
Well, it merely shows the distribution between
the different
earnings and the
benefits.
different sorts of benefits
Yes.
in a rather graphic way. Which,
Thank you.
And of the clip, we're looking at the third page of the clip that's just gone round. The bit with the colour on.
I mean, the headline point is that
The headline
net
point,
earnings of 20,000 become effective at 31,000.
yes,
With
headline point is that if you compare the income of those on benefit to the earnings of those who are working, you will get a false comparison unless you include the in-work benefits. That's the way we put it. The headline point in numbers is the one that your lordship's just put to me. I've made the submission that none of the material we've looked at so far gives any basis for the arriving at the figures in the revised cap. There is not even the tie to earnings, other than the view that I think it's a 4 out of 10. 4 out of 10 working families will have earnings at or below the level of the cap. But that's it. There is no poverty level analysis, no analysis of that sort at all in the machinery we've seen, in the material we've seen. It's just an arbitrary figure. Garnham's witness statement does set out a poverty level analysis. If my lady and my lords will look at her witness statement at paragraphs 55 to 56 at MS 6542. And if you're, my lady and my lords, look at paragraph 55, MS 6543. Points further illustrated by the additional tables at AG3, which the court will find at MS 6613. Ms. Garnham is making the point in paragraph 55 that the tables show where the two claimant households stand in relation to the poverty threshold using the generally accepted measures of 60% of median equivalized income before housing costs and after housing costs, and based on the DWP's own households below average income statistics. And then the headline point is that for both households using the before housing cost measure, just above the poverty threshold before being capped, but below it once capped. And as I say, the table showing all of that is at 6613, paper page 92. Now quite a lot of evidence about different poverty measures, but my short submission is none of it shows a radically different approach. Sorry, none of it shows a radically different picture. A lot of different measures.
Yes, where does the 60% come from? Maybe that's an unfair question. Do you know where the 60%
No, sorry, 60%,
median income comes from?
No, it's an earnings figure, not a income figure. If you're
No, we're talking about the poverty level.
Oh, sorry.
That's what the government uses.
Well,
It's HPAI.
It's one of the topics dealt with in Mr. Ward's statement.
Yes.
Isn't it? Somewhere.
It is.
He seems to think that there are about 3 different measures, or is it 4?
There are. That's why I was asking. There's more.
Certainly are, and I'm not disputing that. I'm just saying you don't get a radically different answer whichever one of them you use.
Follow that.
And it's us that started the analysis. And we get Mr. Ward replying to it all. But no justification. And we've seen all the policy documents that justify the revised cap. Nothing indicating that any serious thought was given to the standard of living that would result from the revised cap, i.e. the reduction to the revised cap. Submission I make for the moment is that all this material demonstrates that the fairness aim is unsustainable if by that aim we mean an attempt to put benefit claimants in a position where they're subject to the same financial rigours as working families. They're being put significantly worse off. Now, at this point, for the first time, I think it is sensible to go to see what was said about this in SG. There's just one paragraph. So if the court will go to volume 2 of the authorities bundle, tab 16, we are in SG, starts at MS 335, first page of the report. And in the judgment of Lord Reed, starting at paragraph 63, that's MS 355, there's a heading, legitimate aim, and the Lord says the next question is whether the regulations pursue a legitimate aim. In my view, that cannot be doubted. And then there's an aim of securing the economic well-being of the country, and some discussion about O'Brien in paragraph 64. Paragraph 65 describes incentivising work. But the third aim is the subject of my present submissions, which is paragraph 66. Now, my submission is that the description of the aim shifts with respect from fairness between those in and out of work to a very different objective. As the third aim is described, that of imposing a reasonable limit on the total amount which a household can receive in welfare benefits. It is again an aspect of securing the economic well-being of the country. It's one of the means of achieving that objective. It also, however, has a broader aspect, namely to reflect a political view as to the nature of a fair and healthy society. As Ministers explained to Parliament, this objective responds in particular to public perception that the benefit system has been excessively generous to some recipients, a perception which is related to the stigmatisation in the media of non-working households receiving high levels of benefit. The maintenance of public confidence in the welfare system so that recipients are not stigmatised or resented is undeniably a legitimate aim. And then reference to Hugendijk and the statement that the benefit system is the means by which society expresses solidarity with its most vulnerable members. Now, when we go to I'm not going to do it, but if one does go to the witness statements of the respondent has put in, that formulation becomes almost the fairness objective. But I have 2 points about it. The first is a mundane point, which is that that formulation was not shared by 3 members of the court. Indeed, their views are expressed in very different terms. It is shared by Lord Hughes. But if your lordships and my lady look at paragraph 134, Hughes agrees with Lord Reed. It's not shared, not even the characterisation of the aim in those terms.
Sorry, Mr. Trouble, what paragraph are we looking at?
134. For
You're
the
dropping
agreement
your
of-
voice quite a lot.
Sorry, my fault. I'll try
And
to avoid
I think we can more or less cope. People at the back, I'm quite
Yep.
sure, wouldn't be able to hear.
I'll do my best.
Well, the microphones don't actually amplify very much. They're there for transmission purposes, not for amplification. So, first duty of counsel is to be heard.
135.
Second duty is to make sense.
If possible.
They're both quite difficult. Anyway,
So that your point you're making is
the
that
point I'm making
formulation
is that the
of policy aim
characterisation
in 66.
in paragraph 66
Yeah.
of the aim is obviously shared by Lord Hughes, see paragraph 134.
135, Roman 2.
What's this got to do with the present case? I mean,
Well, that's I don't.
we obviously, we can go back with interest over what we understood the position to be then, but we have our own evidence in
I
this case.
completely agree with that. I'm not going to be submitting one way or the other that this point is definitive. It is possibly noteworthy that it becomes the description the government put forward of the aim.
Well, if I may say so, it always was. If you look at paragraph 33, you'll see when I spoke about ministers explaining things to Parliament, this sets out or summarises what the minister told Parliament.
The source of the difference in the way in which this is formulated is that certainly when I was drafting my judgment, I relied entirely on the evidence before the court and not on what was said in Parliament. Now, my law, understandably, relied on what was said in Parliament, and that, I think, is the reason why we formulated it differently.
I'm not surprised to hear that. I obviously wasn't a party to the discussions that took place after the hearing. But I'm not surprised to hear that. My point isn't, the major point is not that. The major point is that although it is no doubt possible to describe the matter that's considered in paragraph 66 as a legitimate aim, the amount of traction, if I can put it like that can be placed on an aim, which is related to a false public perception of what people on benefit actually receive, is limited. The heart of it is the statement that just at letter F, page 1470F, as ministers explained to Parliament, that's the point about the parliamentary explanation. This objective responds in particular to a public perception that the benefit system has been excessively generous to some recipients, and then there's a stigmatisation point. Now, my submission is that unless one takes on board the true position, the true relative position of those in work and those out of work, the stigmatisation is not reflecting a real state of affairs. It's a public perception point.
Another way of putting that is that an aim cannot be invested with the status of legitimacy if it depends upon a misconception or a misapprehension on the part of the public as to the generosity or otherwise of the state in granting benefits.
Yes. Yes, I mean, that's the thought I'm heading towards. I don't think it's even a necessary part of my case to say it's not a legitimate aim. It may well be a legitimate aim to ensure that there is public confidence in the benefit system. I understand that.
Yeah, but a fairly delicate ground needs to be trodden here, doesn't it?
Yes.
If you allow public misconceptions to drive your aim in relation to benefits, you need to be very careful that you don't allow ill-informed or prejudiced views to dictate what you should properly do so far as vulnerable members of society are concerned.
What, the very careful bit of that formulation is exactly what I want to submit. It may be a legitimate aim to prop up public confidence in the benefit system, but as a freestanding aim that justifies the effect of the revised cap, one needs to be extremely careful about it, because one is putting the recipients of benefit who are not working at a very considerable disadvantage, additional disadvantage, in comparison to those who are working, who are also receiving benefits. So although I'm not over anxious about saying it's not a legitimate aim or it's irrelevant, it simply, in my submission, cannot bear the weight of justifying the impact of the revised cap which we have been looking at. That, as Lord Conver says, is the issue for this court, not what was said in SG. It's a question of whether the impact of the revised cap can be justified on the line of thought that's in paragraph 66.
In a point that is perhaps obvious, but may be worth making nonetheless, is that what is an appropriate level of benefits is a matter of political opinion, which will differ from one person to the next.
Yes.
And politicians in office respond to the perception of public opinion. Whether it's objectively right or not may not be possible to say.
Well, plainly are going to be elements of judgment which are not for the court. I mean, I don't, once again, don't have any difficulty with that at all. But I mean, if I can just go back to my Lord's paragraph, if I get back to it. Paragraph 66. The third aim, your Lordship described as imposing a reasonable limit on the total amount. So the issue then does become, well, what is a reasonable limit? I fully accept that there's going to be a considerable amount of political judgment in what is a reasonable limit. But where we have got to with the revised cap, as I've been trying to say, is that any link to earnings has gone. Any link to an analysis in terms of the various indices of deprivation or whatever has gone. We are left simply with an arbitrary figure. And it is, with the best will in the world from my perspective, it is very difficult to see how you can describe the thought process that has gone into the revised cap as imposing a reasonable limit. Just is not backed up by any appropriate analysis that would lead to that conclusion.
And given that the figure is the subject of primary legislation, does this form the basis of an argument that there should be some declaration of incompatibility because the figure that Parliament has selected is arbitrary?
Well, we have we don't shy away from that at the end of the day if that's where one gets to. I mean, there's an immense element of déjà vu about this conversation. But we have got at the end of our case an analysis of what might be the appropriate remedy. And I mean, the submission in terms of declarations of incompatibility is that even if I'm right on everything I'm now saying, the language of Section 96 in its amended form doesn't compel a cap which breaches the Convention. One could devise a cap within the language which didn't breach the Convention. And I remember having an exchange with my Lord last time round, if I can put it like that. If at the end of the day one has to use Section 3 to read, of the Human Rights Act, to read Section 96 so as to produce a compatible result, so be it. You don't end up with a declaration of incompatibility, although you may end up with something which is not fully in accord with the policy objectives as articulated by the ministers.
But Mr. Drabble, what's the real target of your case? The 20,000 limit or the requirement of 16 hours of work to escape it?
The target of our case, the target of our case is a combination of both. I mean, the analysis is that if you carry out a discrimination analysis, you have either the lone parents themselves or the children of the lone parents being subject to a regime in which they cannot escape the cap by working, or will not in very large numbers be able to escape the cap by working. And the result is discriminatory in a way which can't be justified.
What's it got to do with discrimination is my problem, Mr. Drabble. I completely understand the forensic point that in the past people have expressed the one-third fairness policy in terms of some kind of equivalence between working households' incomes and work-less households' incomes, and you're setting out to show us that once you take into account in-work benefits, that equivalence doesn't hold good. I understand that, but how far it takes us is, and whether it takes us to unlawfulness or to unsound policy or to neither is a different question. But what's it got to do with discrimination? If you're right about that, it's a flaw in the whole system, isn't it? Your target, as I understand it, is a failure to make an exception for lone parents.
Yes.
But what you have just described applies equally to couples, doesn't it?
Well, it doesn't apply equally to couples.
Doesn't it?
Well, it doesn't apply equally to couples because of they
have a better opportunity of
exactly.
meeting
I mean, as Baroness Hale was putting to me earlier, I mean, it is an important part of our case
Yes.
that it is significantly easier, however one expresses it, significantly easier for a couple where the couple can either do the childcare or the work or share it.
Well, I follow all of that. That's obviously right. But insofar as it is a complaint that the objective set is not capable of achievement because of the incidence of in-work benefits, insofar as that is the complaint, why doesn't that apply equally to couples?
No, because you're starting the discrimination analysis by looking at the impact on the group that we say are being discriminated.
Well, aren't you looking at the difference of the impact between the group that you say is discriminated against and the comparator? Isn't that the point of discrimination?
It doesn't necessarily need a comparator. You look at the impact of the...
I see.
You look at... No, hang on. You look at the impact of the regime on the position of lone parents. It puts them in a position where they're subject to a reduction in their income. That's a detriment. Is the imposition of that detriment justified? Where you look at the aims which the Secretary of State says he's pursuing and see whether they stack up. You
don't need a comparator at all.
No,
discrimination is different treatment, isn't it?
Well, there is a different treatment in the sense that the lone parent is being subject to a regime which is very much more difficult for them to escape.
Okay.
Or even which is not necessarily appropriate in all cases for them to try to escape.
Thank you.
No, I mean, I thought I'd understood this, but I'm getting a bit worried now. I mean, Article 14 must involve a comparison of some sort, doesn't it?
It does, yes.
Yeah.
It doesn't necessarily need an exact comparator, but it
No.
obviously involves a difference in treatment.
Yes.
Clearly.
And isn't what has to be justified under Article 14 that difference of treatment? And you'll look to things like legitimate aim and the other questions in the light of justifying that difference of treatment.
There is a difference in domestic law, whether it applies under the convention. I am wait to be advised between justifying indirect discrimination and justifying direct discrimination. Now, my lord understands what I'm getting at. In SG, the complaint was all about indirect discrimination. As I understand your case, you're saying there's direct discrimination here. Well, no doubt you'll get on to the discrimination bits of it. But in indirect discrimination, what has to be justified is the rule that produces the indirect discrimination. Whereas in direct discrimination, supposing it to be justifiable, which it is in context of Article 14, what has to be justified is the difference. Now, whether that very clear distinction which exists in domestic equality law also applies to Article 14, I don't know.
Well, I mean, the authority that comes into my mind in the course of all of this debate is AL Serbia, as discussed by the Court of Appeal in MA, the bedroom tax case.
But that was direct discrimination. AL Serbia, I think, wasn't it?
But AL Serbia may have been, but the bedroom tax wasn't. I mean, bedroom tax was an indirect discrimination case.
Anyway, maybe you'll get on to how you put your discrimination case after you've gone through looking at the aims and tearing them to pieces, and then you'll see how relevant they are, possibly.
Yeah. Well, let's get on to the next aim in that case, which is work incentivisation. And first sub-issue on work incentivisation is the extent to which the cap is working. Has it actually, as part of the justification for the revised cap, or part of the policy thinking behind the revised cap, let's not use loaded terms, part of the policy thinking behind the revised cap is that the original cap has been shown to work. We don't really accept that. We deal with this in our printed case, at paragraph 55 to 60, at MS 8313. Paragraphs 55 to 60.
Sorry, what's the MS number?
MS
please?
8313.
8313. Yes.
And I mean, the nutshell point here is that despite the government using figures such as 41% of those impacted by the cap being 41% more likely to go into work, that's a quote in the middle of paragraph 56 on 8313, we actually get to a position where the high point of the government's case on the effectiveness of the revised cap is paragraph 59, is that 5%, or 1 in 20 of those subject to it, will be incentivised to move into work by the revised cap. A large proportion will not need this incentive and would have moved into work anyway, around 25% over 3 years. and a larger proportion would have not have been incentivised or unable to find work despite trying. So putting that negatively, that means that 95% of those affected by the cap are not incentivised, successfully incentivised. I don't mean they're not subject to any pressure, but do not in fact move into work, no doubt for all the various practical reasons that are discussed in the evidence. We have that 5% effect. In paragraph 60 of our printed case makes the point that even that 5% claim, which is the high water mark of the government's case, is controversial.
If you believe that imposing a benefits cap will incentivise work, before you have evidence as to whether that actually will accrue, can that be said to be a legitimate aim? In other words, the supplementary to that question is, does it become illegitimate just because in the event it proves not to be true?
I have to say, I always find the three-stage test of legitimate aim, rational connection to the aim, and proportionality very difficult to separate out.
Well, Lord Sumption said that they overlap.
Yes.
But I mean, if in advance of the actual experience you consider that imposing a benefits cap will incentivise work or people going into work, unless it could be destroyed as a philosophical concept, that seems to me to be a legitimate aim. And the question then is whether, if it proves not to be correct, if experience shows that it doesn't in fact incentivise work, is it delegitimised?
Well, I think my own answer to that will be that the aim remains legitimate, but the measure, i.e. the imposition of the revised cap, is either not rationally connected to the aim or alternatively is simply disproportionate.
So when you have the benefit of the experience, you've got to think again, so to speak, in order to maintain the proportionality of the...
Yes, we've got to think... Yes, I mean, I think I give two answers to that. The first is the answer I've just given. That if experience teaches that although you're incentivizing some people, but it's a relatively small number of people, and leaving the vast majority subject only to the detriment but not subject to the advantage, then either the connection between the measure and what would be a legitimate aim were it deliverable is broken, there's no rational connection, or alternatively it's disproportionate, and either formulation would get one to the same place. The other point, which we'll come to in due course, is that the fact that you are imposing a detriment on a very large number of the children of lone parents for no gain to them is a critical factor in the best interest analysis under Article 3, which again will feed back into proportionality or rational connection. And then I just draw attention to paragraph 61 of our printed case, which fleshes out Miss Garnham's evidence to the effect that, and this is just before the various numbered points on MS 8315, the figures do tell us that lone parents who are far more likely to be capped find it much harder than couples to move off the cap, and that lone parents of young children find it hardest of all. And then all the material that's in her witness statement, on which I rely, is set out again. Roman 1 to Roman 4.
Yes.
Now, if I go back to the clip, deal with one of the state of play on the fiscal savings aim, page 6 of the clip. We give the court in paragraph 1 various references to Mr. Edson's witness statement on behalf of the respondent in DS. Headline figures. Of 65 million, for example, in 2016-17, and so on. And he says in terms as based on the August 2016 impact assessment estimates, it excludes any costs relating to DHPs or administration, paragraph 90 of the DA witness statement. And then we have Mr. Ward's evidence. And the headline point is that on the basis of Mr. Ward's evidence, the predicted saving is 42 million per annum for 2018-19. Paragraph 3, we give the court references to the respondent's printed case which are higher. But those higher figures, as we say in the fallout to paragraph 3, do not estimate any DHP spend for 2019 or 2020. It doesn't appear to take account of the additional 8 million local authority costs referred to by Mr. Ward. So
But are you taking into account the whole cost of DHP? Because DHP is paid for more than just to make up benefit cap problems, isn't it? It caters for other problems as well.
That's certainly true. I think the figure for, the relevant figure for DHPs is that in 2C.
2C.
Yep. And the immediate source of that is, yes, it is Mr. Ward's witness statement, and it's MS 9837.
Yes, it is. The 60 million is, according to him, for support of capped households.
Yes, yeah, exactly.
Paragraph 45 of his statement.
Yes, I see that.
I
That answers my question.
Just
Thank
wanting to make sure I was getting it right. I mean,
Yes, yes.
certainly the total budget for DHPs relates to a lot of things,
Yes.
and not just the cap. I mean, Mr. Ward's figures in paragraph 45 at 9837 are specifically capped households.
Yep.
So we do say headline point is basic figure of 42 million net per annum for the next 3 years, paragraph 4. And then a lot of doubt, if I can put it like that, about whether those are being achieved. We give the court references to Ms. Garnham's witness statement to paragraphs 77 to 81. Local authority costs, which we referred to in our evidence again. C. Would be the rest of the, we've given the references to it. I'm not going to go there now at this time of day. But the bottom line submission is it's highly dubious that the cap is actually achieving any significant fiscal savings at all. It's certainly not achieving the hundreds of millions that at points in the respondent's case it is said to achieve.
I'm sorry to be slow, Mr. Drabble. Could you just explain D, the 5D of your clip? What does that... I'm not following it. Other costs, cap people claiming
That's
exempt
the cost of the benefit. Yes. The idea is that if you move off the cap by claiming an exempt benefit, the expenditure on the exempt benefit goes up. So
Why?
because you're claiming a benefit you weren't claiming before. It's working tax credit, and I think it's essentially what we're
If you're
talking
capped,
about.
you're entitled to various exempt benefits, are you?
You get off the cap by claiming your working tax credit.
Yes,
one
follow
of the
that.
routes off. So in order to work out what's being saved, you have to bring into account the cost of the additional claim.
Oh, that's what that means?
Yes.
Oh, I see. All right.
Basically, by getting into work,
Yeah,
you then
yes.
get benefits as a working person.
Yes.
And so you say there is no saving
Well, to that extent, there is no saving.
to that extent.
Yeah, yes, I mean, you have to let it off. It's part and parcel of the fact that the comparison...
It's in work benefits, is it? Is it? I mean, it's not what it says, but that's what it means.
Well, I don't know, we're going to argue about whether it's
No
what it says or not.
Right.
It's capped people who cease to be capped because they've claimed an exempt benefit. That's
Capped people who
capped
cease
people claiming an exempt benefit is a shorthand for the idea that you were capped. You claim your working tax credit. Of course, you've claimed your working tax credit on the back of sufficient work. You are no longer capped, but you are getting the benefit.
But oh well, there we are. I mean, all right.
I can give your lordship.
It's not worth spending a lot of time on this.
No.
That's
I'll
what it's
just
meant
give you
to
the
mean.
reference.
I've got it.
Paragraph 80 of Miss Garnham's witness statement, MS 6548,
Thank you very much. I'll look it up.
paper page 27 of Appendix 1. And 4 or 5 lines in, significant proportion of those moving off the cap do so by claiming an exempt benefit.
So you're not actually saving any money
Well,
by
there's a
moving.
trade-off.
This is the point.
There's a
because
trade-off.
they're getting other stuff.
You can't
instead.
just treat it as a gross figure. You have to.
That's the point.
Yeah.
Well, it's possible to speculate that there would also, when we're talking about increased costs to local authorities through homelessness, but it could be that there will be increased costs to local authorities through having to accommodate children because their family simply couldn't afford to make ends meet.
Yeah, I mean, if the court has the time to read the references in C of this note, so I'm not going to do it now, to the increased costs on the social services budget. And simply employing extra workers to deal with the administration of social services as a result of the cap. I think it's Southwark that has to employ 3 where it previously employed 1. And these are quite significant costs.
I think we may have taken you to a convenient moment, Mr. Drabble, have we?
Oh, yes. I'm being told from all sorts of sources that we're at a convenient moment.
Very well. Well, we will adjourn now and hear from you further tomorrow morning. It's 10:30 tomorrow morning, is it not? Yes.
Indeed.